Every time someone visits a doctor, fills a prescription, or files a health claim, sensitive information about them changes hands. In the United States, a single federal law shapes how much of that information can be used and shared. It is called HIPAA, and it is one of the most misunderstood rules in business. In the next few minutes, we will explain what it actually covers, in plain English. HIPAA stands for the Health Insurance Portability and Accountability Act. It was enacted in 1996, and while the name suggests it is mainly about keeping health coverage when you change jobs, the part most people know today is about privacy and data protection. Over the years, a series of rules built on top of the original law turned it into the backbone of health data protection in the United States. The information HIPAA protects has a specific name, Protected Health Information, or PHI. In plain terms, that means individually identifiable health information, any detail about a person's health, care, or payment for care that could be linked back to them. When stored or sent electronically, it is often called ePHI. This covers far more than diagnoses. It can include names, dates, contact details, and billing records when they are tied to someone's health. The framework came together in stages. The law itself arrived in 1996. The privacy rule reached its compliance date in 2003. The security rule followed in 2005. And in 2009, a separate law called the HITECH Act added breach notification requirements and strengthened enforcement. Each piece answered a different question: what can be shared, how it must be guarded, and what happens when something goes wrong. Here is one of the most important things to understand: HIPAA does not apply to everyone who touches health information. It applies to specific categories of organizations. The first group is called covered entities, and there are three types. Health plans, such as insurers. Healthcare clearinghouses, which process health data between formats. And healthcare providers, meaning doctors, hospitals, pharmacies, and clinics, but only those who transmit health information electronically in connection with certain transactions, like billing a claim. The second group is business associates. These are the vendors and partners that handle protected health information on a covered entity's behalf. Think of a cloud storage provider, a billing company, or a software platform used by a clinic. Originally, HIPAA reached these vendors mainly through contracts. That changed with the HITECH Act and the 2013 Omnibus Rule, which made business associates directly responsible for many of HIPAA's requirements themselves. Why does this distinction matter? Because whether an organization has to follow HIPAA depends less on the data it holds and more on what kind of organization it is. That single idea clears up much of the confusion around the law. With that in mind, here are the three rules that do most of the everyday work. The privacy rule is the part of HIPAA that governs how protected health information may be used and disclosed. Its compliance date was 2003, and it applies whether the information is on paper, spoken aloud, or stored electronically. At its heart is a simple idea often called the minimum necessary principle. When a covered entity uses or shares PHI for routine purposes, it is generally expected to limit that information to the minimum reasonably needed, rather than hand over an entire record when a single detail would do. There are important exceptions, such as sharing information directly for a patient's own treatment. The privacy rule also creates rights for individuals. Under the rule, people can generally ask to see and receive a copy of their own health records. They can request corrections when they believe something is inaccurate. And they can ask for an accounting of certain disclosures, essentially a record of where their information has been shared. These rights shift some control back to the individual, which is a large part of what the privacy rule was designed to do. If the privacy rule is about what may be shared, the security rule is about how electronic information must be guarded. Its compliance date was 2005, and it focuses specifically on electronic protected health information, or ePHI. The security rule organizes its protections into three categories of safeguards. Administrative safeguards are the policies, training, and processes an organization puts in place, such as assigning responsibility and managing who has access. Physical safeguards protect the actual equipment and facilities, covering things like locked rooms, device controls, and secure workstations. Technical safeguards are the technology-based protections, such as access controls, audit logs, and encryption where appropriate. The security rule is also designed to be flexible. Rather than dictating one rigid checklist, it expects covered entities and business associates to assess their own risks and apply reasonable and appropriate measures for their size and situation. A large hospital and a small clinic can meet the same standard in very different ways. Even with strong safeguards, incidents happen, and that is where the breach notification rule comes in. It came from the HITECH Act in 2009, and it sets out what has to happen after a breach of unsecured protected health information. The core requirement is notification. Following such a breach, affected individuals generally must be notified without unreasonable delay, and no later than 60 days after the breach is discovered. The organization also has to notify the Department of Health and Human Services. And there is an additional step for larger incidents. When a breach affects 500 or more people in a single state or jurisdiction, prominent local media must be notified as well, so the public is aware. The word unsecured matters here. The rule is generally focused on information that was not rendered unreadable, for instance through appropriate encryption. That closely links strong technical safeguards and breach notification in practice. The goal of the rule is not to punish, but to make sure people learn promptly when their sensitive information may have been exposed, so they can take steps of their own. So who enforces all of this? HIPAA is overseen by the U.S. Department of Health and Human Services, primarily through its Office for Civil Rights, often shortened to OCR. When there is a complaint or a reported breach, this is the body that investigates and can require corrective action. Penalties are structured in tiers based on culpability, meaning how much the organization knew and how it responded. Civil penalties can range from roughly $100 to around $50,000 per violation, with annual caps that can reach into the millions for repeated violations of the same requirement. In cases involving knowing, wrongful disclosure of health information, criminal penalties can also apply, with prison terms reaching up to 10 years for the most serious offenses committed for malicious or personal gain. These figures are approximate ranges, and they are adjusted over time. Now for the misconception. Many people assume HIPAA covers all health data, everywhere. It does not. Because the law applies to specific covered entities and their business associates, a great deal of health-related information falls outside it. Most consumer fitness trackers and wellness apps, for example, are generally not covered, because the companies behind them usually are not covered entities or business associates. The same health metric can be protected in one setting and unregulated in another. So here is the shape of it. HIPAA is a U.S. law that protects identifiable health information held by particular organizations, including health plans, clearinghouses, most providers, and the vendors who work with them. It sets rules for how that information can be used, how it must be secured, and what happens when it is exposed. Understanding those boundaries, including what falls outside them, is the first step to reading any HIPAA headline with a clear eye. If this cleared up even one thing about HIPAA, consider subscribing to Compliance Decoded. We break down one regulation at a time, in plain language, so you can follow the rules that shape modern business. And we want to hear from you. Which health data myth have you run into most often? Drop it in the comments, and we may tackle it in a future video. Educational overview only, not legal or compliance advice. Consult a qualified professional for your situation.